I'd like to introduce, and I'd like to first thank the Attorney General's office, who has been here and present at this conference for every single year that we've done it. We really appreciate that, and I'm sure the folks in the audience do. I'd like to introduce Sharon Sash, who's an Assistant Attorney General in the Charities Bureau of the New York State Office of the Attorney General. She joined in November of 2017 and spent 6 years exclusively in the Charity Bureau's enforcement section before now transitioning to the one that our firm spends more time with, which is the transaction section. And to her side is Stephen Thomas, who's an Assistant Attorney General in the enforcement section of the Office of the Attorney General Charities Bureau. He's joined in 2019 and has experience litigating to trial issues affecting charities, ranging from a charity's failure to properly manage charitable assets to individual fiduciaries' conflict of interest and breaches of their duties. So basically, you want to try to avoid Stephen as much as you can. Sharon, just half the time now. So, thank you.
Good afternoon. Stephen and I want to thank Capel Barnett and the Interchurch Center Conference for inviting us to speak to you this afternoon. It's our pleasure to do so. The Charities Bureau of the Office of the Attorney General really appreciates being part of this event, and we, as Renato said, have been doing so for the past, since its inception. So we truly enjoy coming to speak to you. In addition to today, we do a lot of outreach events across the city and even across the state. We're happy to answer questions after our panel and on an ongoing basis. So we're happy to provide our contact information. I'm not sure if it's in the pamphlet you received, but please, reach out to us at any time. So what are we going to talk about today? So today's program focuses on corporate governance in not-for-profit and religious organizations. So we are going to talk about the types of duties that directors, which your organization might also know as trustees of your organization, or even by some other names, officers of your organization, and what we call in the law key persons, which can be, are people that sort of have a lot of influence and authority over your organization, the types of duties that those individuals owe to your organization, what they need to do to avoid breaching those duties, and how those duties play out in a few real-life examples that we'll talk about today of various enforcement actions that our Bureau has taken, as well as transactions that we've been involved in concerning the sale or other disposition of charitable assets that your organizations might have engaged in or might be contemplating in the future. So to give a little bit about a background of what we do, I don't know where we are. Can you advance? The Attorney General's office has the power and responsibility to regulate the charitable sector to ensure that charitable assets are preserved and used to fulfill a legitimate charitable mission and for the benefit of the ultimate charitable beneficiaries. The Attorney General also has the responsibility to protect against the misuse of charitable assets through self-dealing by insiders, including improperly bestowing benefits on individuals that do not serve the charity's mission or other forms of private benefit. The Attorney General has a statutory responsibility to ensure that charitable entities and the people that oversee and run those organizations fulfill all of their duties and obligations to those entities. Our Bureau has 4 sections. We have a transaction section, which deals with the disposition of charitable assets, and you may encounter that if your organization is seeking to sell real property that it might own, which is usually its most valuable asset. For religious organizations, if you want to mortgage that property to borrow money against it, for example, to fund a number of different things. The enforcement section, which I used to serve in and Stephen currently is in, which gets involved when things go awry. and Stephen's going to talk a little bit more about that later. We also have a trust and estate section, and we have a registration section. And some of you might be familiar with the types of registration that's involved. You have annual filings. Most religious organizations do not, but not-for-profits that are non-religious generally do. And those are in addition to whatever federal requirements might exist with the IRS. And we're going to talk a little bit about that as well. So let's see where we are.
Do you want to talk about enforcement?
Yeah, sure. So, well, I can talk a little bit about, you want to talk first about enforcement and then I'll talk about transactions?
Sure.
Go ahead.
So what I do want you all to take away about enforcement is that we are not the boogeyman. It is true that enforcement is the section of the Charities Bureau that gets involved when things go wrong, generally speaking. But things can go wrong for a lot of different reasons, some of which, maybe a great deal of which, can have nothing to do with your organization or your organization in its entirety. For example, if somebody is stealing money or embezzling money from your organization, that is a situation where we can get involved and we can be of great benefit to your organization, to your churches, your places of worship. We have tools that allow us to get that money back in some circumstances. And unlike a lot of my sister sections or bureaus in the Attorney General's office, the money that we in Charities recoup does not go back into like the public treasury. Instead, it is either going back to the charity that was affected, or if that charity doesn't exist for whatever reason, it will go to through it's a legal term, but it's called cypre. It gets put into a charity that has a similar mission. So that is what we do. Money is not coming to us. We are not benefiting from it. Our entire purpose is to be supportive of the charitable sector and make sure that your money, the money that your congregants, your members, your donors are providing to you, is being used for the purpose that they expect it to. We'll get a little bit more into examples later, but a prominent example that I have personally dealt with involved the CEO of a nonprofit for years getting free luxury vacations from one of the largest vendors of the organization. And in exchange, that vendor was getting tens of millions of dollars in business from the organization for about a decade. And so, that is an extreme, but it is important if you have an issue that you think we could be helpful in addressing, that is what we're here for. And we are here for you to come to. Tell us about problems. Tell us about mistakes that you've caught. Tell us about what issues you're facing, and we will see what we can do to support your organization. That is our objective. And with that, I'm going to give it back over to Sharon.
Okay. To sort of piggyback on what Stephen has already said, we and one of the things I think I want to emphasize most is that a lot of times religious organizations don't quite realize the importance of the role that fiduciaries play in the organization. And when I talk about fiduciaries, I'm talking about your board, right? So religious organizations need to have a board of directors or a board of trustees or other governing body that's helping to run the organization. Their officers have to be people that are putting their loyalty to the organization above all else, and key people that run your organization. One of the things that we see frequently, and we're going to talk, about that more, including an enforcement action that we had that arose out of what we call founder syndrome, or with religious organizations. A lot of times, you have a head pastor, for example, who is the, head of the religious organization and has a tremendous amount of deference paid to him or her, sway over the organization. And what we want to emphasize today is, even if that's the case in your organization, the board, the trustees, or the directors have their own fiduciary responsibilities to the organization to keep that person in check. And so in one of the examples we'll talk about today, we had an enforcement action, and it was one that I was personally involved in, where we had a situation, we'll talk more about it, where clergy were receiving payments from a developer that were undisclosed, and it was compromising their duties and obligations to the organization. We'll talk a bit more about it, but so how did that enforcement action arise? It actually arose out of several transactions that our office had approved. So what does the transaction section do if you haven't encountered us before? So what do we do? In the Attorney General's role as the protector of ultimate charitable beneficiaries, it's our responsibility to make sure that the charity's transactions that it's entering into and how it's using and disposing of its assets are fair, reasonable, and in the interests of the charity and the mission of the charity or the interests of its members. And so we have a statutory framework that actually requires that when you enter into that kind of transaction, let's say you want to sell a piece of your real estate. It could be your house of worship. It could be a parsonage. It could be other real estate that the organization owns and maybe derives rental income from. For a religious organization, it's actually any of the assets need to come to either our office for approval or the court. And if it goes to the court, it still has to be on notice to the Attorney General, so we need the opportunity to weigh in on it. And we either approve the proposed transaction or, we would object. And we'll talk about a situation where we recently had, where we did object to the sale of a very valuable piece of property, and why? Why do we do that? So what kinds of transactions are covered? What do you need to come to us for? So it's the sale, lease, exchange, or other disposition of all or substantially all of the assets of a charitable organization, a non-religious, or in the case of a religious, any of its property. And for religious organizations, we also have to approve mortgages. So that's frequently what we're seeing in our office from religious organizations is borrowing against the property to try to take money out, whether it's to renovate the sanctuary or it's for operating or it's to deal with the payment of liens or other things that are might have been imposed on the organization. Okay, so Stephen's going to talk now about what kinds of duties exist. What does your board of trustees and your officers and your key people, what do they have to do to help keep the organization running smoothly?
So to begin with, Sharon and I are both guilty of being lawyers, and that inevitably comes with legalese. And I'm going to do my best to put it in as simple and plain and real English as I can. But there are some legal terms that we necessarily have to talk about. But if at any point you have any questions about anything that I've talked about or confusion about the Latin or other words that come out of my mouth, please just let me know. And this is more for your attorney's sake, but we have a few statutes that are the primary sources of the Attorney General's authority to regulate charities. That's the Not-for-Profit Corporation Law, the Religious Corporations Law, and the Estate Powers and Trusts Law. And the Not-for-Profit Corporation Law is sort of the overarching law that tells not-for-profits how they need to organize themselves, having a board of directors, how to have meetings, how to interact with your members if you're a membership organization. And the not-for-profit corporation law applies to religious corporations as well, except when it doesn't. And I'm going to leave the except when it doesn't to your lawyers to talk to you about. But for my purposes today, we're going to be talking mostly about fiduciary duties.
And those do apply to religious organizations.
Which do apply to religious organizations. So I'm actually going to skip ahead here to this. When we talk about fiduciary duties, these are the duties that apply to the people in charge of your organization. And that means your board of directors, your board of trustees, your board of deacons, as well as your equivalent of a CEO or a managing director, whether it's your head pastor or whoever it is who is ultimately in charge of your organization. And your bylaws often will set out who the officers are, who are the people with this fiduciary responsibility. And when we talk about these fiduciary duties, they fall into these three categories. You have the duty of care, which at its most basic is the duty to be curious and the duty to ask questions. If you have a board, they are not supposed to be potatoes, just sitting there and absorbing information without actually doing anything about it. They need to be asking the right questions to make sure that the organization is following the mission that is set out in your certificate of incorporation, in your bylaws, whatever your mission is, it is the duty of the board to make sure that it's being followed. Then you have the duty of loyalty. And at its most basic, the duty of loyalty is the duty to be conflict-free. There are certain situations where a conflict of interest is not necessarily a bad thing. And that is, we'll talk a little bit more about that later, but it's spelled out in the not-for-profit corporation law. But you could very well have a relative who has a business who is going to get you a great deal for your organization. But you cannot be the one to make that decision. It has to go to the uninterested, the unconflicted fellow members of your board or officers who are making that decision. It cannot be you, and it has to be disclosed. You can't make a decision about any sort of business enterprise or partnership or having your brother-in-law come in and do the plumbing for the organization without disclosing to everyone else who they are and your relationship to them. It is vitally important. And then last, we have the duty of obedience. And this is actually one that's unique to not-for-profits. So the first two, duty of care and loyalty, apply to for-profit entities as well. But the duty of obedience is about your mission. It is about your reason for being. And it is important that your board is making sure to follow through with what your mission is, whatever it is. Whatever your mission statement is, that is what they must obey. And as a corollary to that, they also need to be obeying all of the laws that go around being a regulated entity like a not-for-profit. There are a lot of rules, both from the IRS at the federal level, as well as from us at the New York level. And you have to be in compliance with those laws because otherwise you're putting your organization at risk. You are putting your mission at risk. Because if the IRS comes in and says, you've been doing too much politicking and you're not allowed to do that, and so we're revoking your tax-exempt status, that is a huge problem, I'm sure, for any organization. And it's something that has to be avoided, and it is the duty of the board and the officers to avoid situations like that, or to rectify them when problems happen. So what does this look like in practice? I'm mostly talking about the board of directors level here, but this really does all apply to your officers as well. But I really want to get at your highest governmental body, whatever it happens to be. You need to read your documents. You need to be familiar with your bylaws and your certificate of incorporation. What do they say? What do they allow? What do they not allow? All of that is vitally important in order to be an effective governor of the organization. Yeah, of course.
So on the bylaws, one thing we've noticed in our bureau over the years is that particularly with religious organizations, the bylaws are extremely outdated. You may have bylaws that look like they were typed on a typewriter or even handwritten, and they are from 1962. They do not address what the law actually requires now. And there's a requirement that all of your organizations have conflict of interest policy, an actual conflict of interest policy. And there's annual disclosures that may be required. Everybody has to fill out every year what their conflicts of interest are, so everybody in the organization knows. Some organizations might have to have a whistleblower policy, also a super important, thing. And so bylaws, not only must you be familiar with them, but if you take a look at your bylaws and you see that they look like they are from the dark ages of before the dawn of time, you want to talk to your organization's counsel and certainly bring up at your next board meeting the fact that these bylaws need to be modernized and brought into what the actual reality of the organization is. Same with your certificate of incorporation. We see a lot of times, in transactions, when your organization comes to us to try to do a transaction, we take a look at your certificate of incorporation and we take a look at your bylaws. Very frequently, there's actually contradictions between them. Your certificate of incorporation might say you must have 3 trustees. We take a look at your bylaws and it says you have 18. So, that's an issue, a problem that you as, trustees or directors of an organization should be kind of aware of and making sure that you're in compliance.
And to that point, 2 things. One is you should be looking at your bylaws anyway, but in 2014, there was a pretty significant change to the not-for-profit corporation law in New York. It was the Not-for-Profit Revitalization Act. So certainly, if you have not looked at your bylaws since 2014, it would be a very good time to do so. And then also think about the sort of practical help that could come from changing your bylaws. As we all know, COVID was terrible, but what a lot of organizations discovered is that their bylaws did not allow for teleconference meetings of the board. And so it was like all in-person requirements. And obviously that was not possible for most of us during that time. And so being able to modernize your bylaws and allow for, remote voting or whatever sort of small quality of life changes can make a really big difference for you and your board. And help you, get through tough times easier. All right, so the next I have up here is understanding your organization's tax-exempt status. I am not suggesting that all of you should become IRS or tax code experts. I am not, and I do this. But there are basics that your board in particular should be familiar with, your officers should be familiar with. What is your organization allowed to do? What is it not allowed to do? What brings with it the possibility that the IRS will come knocking or breathing down your neck? Those are things to be avoided. They're costly to handle, and they put your organization at risk. So we think of that as being under both the duty of care and the duty of obedience. Follow the law. Next is having a plan for the future. Your board needs to know what the future is going to look like for your organization. And that can take many, many different forms. You can have a growth plan. You can have a plan that, things are good right now and this is how we want to keep them this way, but here's how we're going to do that. Or your organization could be reaching the end of its life and you need to figure out what happens next. I think you're going to have a panel a little bit later today on, the end of life for an organization, but that is a part of the duty of the officers to think, how are we going to wind this down? How are we going to be elegant about it? How are we going to prevent the many, many headaches that can occur from that? How are we going to sell it to transactions and make sure that they're okay with and on board with everything that we're doing? That is a very important part of the planning process for your board. So I already touched on this, but again, asking questions is just such a vital part of being a good fiduciary. If somebody comes in and is painting you a rosy financial picture, but you're on the ground and you're seeing what it's like and you have some questions about that. Are you sugarcoating things for me? Can I see the backup for this? Like, what are you basing your optimism on? These are important questions for a board to ask. Unpleasant questions for staff to deal with. I completely recognize that. But nevertheless, it is a part of the duty of care.
Mm-hmm. Good governance. What's your financial picture? That is something that is so critical, particularly, with all not-for-profits. But a lot of times, religious organizations in particular may not be very large organizations with a ton of revenue, right? Like they might be smaller operations where, as I said before, a pastor, for example, is really the head of the head of the show there. A board of trustees, good governance is making sure that you know what the financial picture of that organization really is. And it doesn't mean that you need, sophisticated outside auditors to be coming in and, auditing financials where your revenue might be, your tithing or your, income might be after expenses, pretty small. But it does require that your organization is, well run with tight controls. Who has access to the money, right? Making sure that, for example, you have, multiple people are required on the checking account, on the operating account to take out withdrawals that are not, the typical, routine expenses like payroll or things like that. But if somebody is, taking money or accessing the funds, that there's multiple people that are looking at that transaction and have to sign off on it. Who actually has access? Where are your bank statements going? Are they going to, to just the pastor? And I don't mean to, make the pastor into something nefarious, but are they going into any one person? Does one person only have the password to the online banking? That's not a good practice, right? Like that just leaves open the possibility of things going awry. So again, asking questions, making sure you have tight controls on your finances, those are all super important.
Just to piggyback on that briefly with another real-world example, one of the cases that I have been handling for the past several years involved, among many other things, a CEO who was having his expense reimbursement requests were being approved by his secretary. I don't think that this needs to be emphasized a lot, but it is not a good practice for somebody junior to the person to be approving their expenses. That is not the way that it should go. That was the board's responsibility and one that they were not following through on. All right, so the next one it's such a thankless task until it isn't, and then it becomes the most important thing in the world, but it is good record keeping by the board. Your board should be having minutes. Those minutes should be as detailed as you can make them, and they should reflect what was done, what was considered, what was the outcome, who voted, or what was the type of vote, and what was the outcome of that vote. And especially in situations where you are dealing with a conflict of interest, and a conflict of interest that you may want to approve because it is, in fact, in the best interest of the organization, you need to make sure that that is documented as best you can, because you want to have a very strong record that we looked at this, we market tested it, we compared prices, we looked at what reviews this person has, whatever it is, and whatever scale it is. You need to make sure that it is very clear that what you are doing is in the best interest of your organization.
Again, one thing that boards sometimes don't realize is that they can go into what's called executive session. I don't know how familiar people are with that concept, but you're having a board meeting and your ED, your executive director, comes to the board meetings. Right? That person comes to the board meetings maybe and gives a management report to the board. After that person is done, there is nothing wrong with the board going into what's called executive session, telling the management, the executive director, whoever, the pastor, whoever it may be, you need to step out now, and you can't be part of this next conversation. So if there are hard decisions that have to be made, or things maybe that the board is concerned about, the board takes a look at the finances and says something looks a little weird here, or things are just not quite adding up, you can, well within your rights and actually your responsibility to go into what's called executive session and talk without management present, and have frank conversations about whether the organization is, not fulfilling its mission, it's not meeting the goals that it's supposed to be meeting. Those are all really important parts of being, a fiduciary, what we call a fiduciary to the organization. So don't be afraid of that. And do not, be intimidated. We call it founder syndrome. There's organizations, right, where the person that founded the organization back in, 1972 is still running the show, and everyone defers to that person, right? It's a small organization. It might even be a mom and pop organization. And sometimes the board, if you're not, there's a lot of trust that goes with that, right? So there may just, even the board may have been the same since the inception of the organization, and you're all good friends. It's very difficult, in that situation for the board members to say, this person might not be doing something that's right for the organization. And the board has its own independent obligation in that situation to act on behalf of the organization and not succumb to what we call founder syndrome,
Right, and your board is the boss. Your board is where the buck stops. It is not with your chief officers. It is not with your pastor, your head pastor, your CEO, your managing director, whatever term you use for the non-board officers. They are not the ones who get to make those ultimate decisions. It's the board, which is not to say that it should be a combative relationship. It's very important to work cooperatively, but it is the board that needs to make the hard decisions sometimes. And sometimes those decisions are not, favorable for your chief officers. But that's what the board is there for. It's to keep the organization's interests in mind, even if that is to the exclusion of the chief officer. Oh, okay, yeah, so I think I have a little bit more detailed slides about, I did want to talk about conflicts a little bit more. So as I mentioned, and as Sharon mentioned, the not-for-profit corporation law requires all organizations to have a conflict of interest policy. That's something that's new with the 2014 Act I mentioned earlier. But you need to make sure that you have one, that it follows, and this is all questions for your counsel, obviously, but to make sure that it follows the statute. And it is designed to make sure that conflicts are disclosed appropriately, that they are handled appropriately. And again, we're not saying that conflicts of interest are necessarily bad, although undisclosed conflicts of interest are necessarily bad. It is important that you give your board the opportunity to make a full and fair assessment of whether or not this is a good thing for the organization.
One particular type of conflict of interest is what we call in the statute a related party transaction. And I just want to mention that, emphasize it, because where does that come up? That's in transactions. Your organization may come to our office and say, we want to sell this piece of property, and we do an assessment. The property, I'm just making this up, the property is worth $5 million. And here's our appraisal showing that this is actually the fair and reasonable consideration that we're getting, and we're selling the property to this person, and they're going to buy it, and we're going to get $5 million out of it. One of the pieces that we look at very carefully is, what are you doing with the proceeds? Okay, so frequently we have organizations that will come to us and say, by the way, out of the $5 million, we need to pay off an existing mortgage, let's say, and that's $2 million. But oh, by the way, there's $1 million in loans that we have to pay back to our director or an officer who lent us money along the way. Maybe people are nodding. This happens quite frequently. And the organization cannot make loans to a director or officer. That's a different issue. But frequently, directors and officers do make loans to an organization to keep it afloat, or maybe a congregant, or people have lent money to your organization. So one of the things, and the organization wants to use some of the proceeds from the sale of their property to pay back these loans. That would be what we would call a related party transaction, which means a party, an officer or director or a person that has authority in the organization is actually getting some kind of, has an interest in the transaction, right? Like they have an interest, a financial interest in seeing that the transaction goes through. So the statute requires certain things be done in that situation. That person can't vote, right? So if one of the things we need to see is that your board approved the sale, but the use of proceeds would involve paying back this director, $500,000, that director would need to not be part of that vote, right? They would have to recuse themselves because they have an interest in seeing the transaction go through. They have a real financial interest. In transactions, when we review your use of proceeds, we are going to look for backup for the purported loan. So we get an application in and it says, we owe this, we're going to pay back our CEO $500,000. He or she loaned us that money over the course of the last 10 years. One of the things we're going to look for is, do you have backup for that? Is there some papering of that transaction? It could be a promissory note, which would be great. There's an actual note that says I'm loaning you this money and you're going to pay it back. But organizations don't always have that. And that doesn't mean we won't ever approve that. But we are going to look for other substantiation of that. Are there board minutes maybe that reflect that, right? That 10 years ago, the CEO said, I'm in a position to lend the organization $500,000, and the board talked about it and somehow reflected in the minutes. Is that liability on your financials, right? Is it being carried on your financials as some kind of liability that the organization owes, right? Because that's some evidence that the organization understands that to have been a loan that it owes back. Is there, sometimes we might even ask for a bank statement that shows the money going into the organization's account at the time. We don't care what the account number is, but we want to see that, okay, they lent you $50,000 in March of 2018. Let's see the organization's bank statement from that period showing the deposit of that money into the organization's account at that time. So those are all, real world examples of what our office might look for if your organization is seeking to pay back those kinds of things. We also see that, for example, the organization has no money, right? They're going to sell this property and they're going to come into a lot of money. And they now are saying that they owe the pastor, 10 years of back salary. They haven't paid him in 10 years. So, okay, again, we're going to take a look at that and, really take a look. How have you been sort of accounting for that on your financials? Is there a line item maybe that says salary owed to pastor? How has the pastor been living for the last 10 years if they're getting zero salary? Again, all things that a board and good governance would require you to be on top of. So it's not that loans from officers or directors can't be legitimate, but they should be papered properly, right? Like there should be some actual evidence that it was in fact a loan and, what the terms are and when the pastor or whoever it is going to be paid back. So we should probably get into our examples. I think we're probably running a little short on time. So some examples, recent examples. These are real cases that happened, and obviously anything on here is now public information. So Oh, United Grand Chapter. Okay, so United Grand Chapter is very recent. Actually, just happened in the last. I don't know if any of you are familiar with this particular situation, but let me just see where I am here. Okay, so in United Grand Chapter, this dealt with a property in Bedford-Stuyvesant, down in Brooklyn, and the organization had first sought to get our office's approval to sell the property back in 2021. A lot of back and forth with our office, and it ended up resulting in litigation. So again, this was a property in Bedford-Stuyvesant. It at one time contained a mansion on the property. It was called the Jacob Dangler Mansion. And it was owned by the charity, and the charity operated out of that. Organization actually had, unfortunately, a long history of some financial mismanagement, including fraudulent mortgages taken by insiders on the property, which resulted in a foreclosure action against the organization. So insiders had fraudulently obtained mortgages and absconded with the money. The organization apparently never received the funds. So it's a very complicated fact pattern, but basically the organization was seeking to sell the property to a developer. And our office did not believe that the consideration, the price being paid for the property, was fair and reasonable. We actually commissioned, in that case, our own appraisal, which we will sometimes do, because we did not agree, we did not think that it was being correctly appraised. While the petition was pending in our office, the organization allowed the developer to demolish the building. Also so happened that while that was happening, individuals in the community were actually trying to get the building landmarked. So it was in landmarking, and apparently there was some 4-day lapse between landmarking and Department of Buildings, and the developer went in and demolished the mansion. We opposed the sale for many reasons, including that the consideration was not fair and reasonable, but also that the history of the financial mismanagement and the mismanagement by the organization and the board, who is running this organization, who is actually signing off on allowing all of this to happen, and the same people that were in place as directors and officers at the time the fraudulent mortgages took place were still running the organization. So we objected, and it was, pretty hard fought. And Justice Maslow in Brooklyn just issued an opinion, and he denied the sale. He agreed with us and denied the sale. So that was a very recent example. It just happened. What was that? Oh, I mean, some might say bravo. The organization is still in foreclosure, and by the way, who owns the debt in the foreclosure? The developer. The same developer is now the person also seeking to foreclose. So it's a very complicated story, but that is going on right now. It just happened. That's one example of, again, boards not doing maybe what they should be doing, and the real life consequence of that, right? Our office objected to it, and the court agreed with us. They can't sell a building to this developer. Okay.
So I'm going to just very briefly talk about, we had, back in 2018, we started investigating a number of the Catholic dioceses across the state. And that resulted in 2020, we brought a complaint against the Buffalo diocese. And very high level, our allegations involved the diocese were not following their own policies and procedures around how the allegations and investigations into sexual abuse should be handled. It was either just not following the policy at all or inconsistently following the policy. And as we discussed earlier, following your own policies, following your own organization's dictates about how things should be done is a part of your fiduciary duty. And so we went in, and that ultimately resulted in a settlement back in 2022. And then we also, just earlier this year, announced it's called an assurance of discontinuance. It's a fancy term for a settlement before actual litigation happens. And that was with the Brooklyn Diocese. And there's still some stuff being negotiated there, but the AOD, the assurance of discontinuance, is available online. It's 90 pages, so I don't recommend reading the entire thing. But in my opinion, it shows a lot what cooperation with our office will do in terms of like how we resolve a situation. So the Buffalo Diocese, that was litigation resulting in a settlement, compared to the Brooklyn Diocese, which was a much more cooperative endeavor resulting in a pre-litigation settlement. I'll let you guess which one of those was more or less expensive for the organization. And next, yeah.
Okay, so the last one we're going to talk about, and I think we talked about a couple of years ago. So, but this is a great example particularly for religious organizations. So, and again, these assurances of discontinuance are also available online. They're publicly available, as is the lawsuit we brought. But basically, we started an investigation in 2017. There were 7 real estate transactions that came into our office. Same developer was buying them. It was 5 churches that were with one particular denomination in Harlem and one in Brooklyn, and 2 that were in another denomination, also in Harlem. They were all approved. The transactions were approved. They were being sold to this same particular developer. I'm intimately familiar with this one because I actually was the enforcement person that did this investigation. So we started to realize that the developer was not fulfilling what he said he was going to do on these transactions. So we had an investigation that lasted several years, and we ended up discovering that the developer was paying kickbacks, you want to call it, secret payments to clergy in order to push along to get this developer to be the developer and to sort of push along these transactions, obviously to the detriment of the church. So in one particular denomination, it was a very senior person in the hierarchy. This was a hierarchical organization. So one was a bishop in the hierarchy. One was an elder in the same hierarchy. And then in another denomination, it was actually the pastor of one of the congregations. And they were receiving substantial monetary payments from this developer, basically in exchange for one, pushing along the approvals that were needed within the hierarchy and in the organizations. But also when the developer failed to perform, they were not enforcing the terms because they were compromised. So these, individuals, in one case it was the person was actually on the board of directors as well. And in the other 2 cases, they were what we would call officers or key people, right, in the organization. They were allowed, and who's suffering? The churches, right? The churches are suffering, and these conflicts were obviously not disclosed. They weren't disclosed to the actual churches. They weren't disclosed to our office. They weren't disclosed to the court, and so we ended up reaching assurances of discontinuance with the developer, which is actually still being monitored because there's 5 of those buildings that were contracted for in 2015, 16, and 17 still have not been finished in 2024. And we reached settlement with 2 of the clergy. So I think you can probably go to the next slide. So we ended up with one of the clergy. We recovered, he was required to pay the full restitution, every single penny he got from this developer, we recovered. $610,000 plus the value of a luxury watch that he was required to sell. And all of those payments were given back. We dispersed those back to the 5 affected churches in the denomination that he oversaw. The other one paid back $200,000, which is actually still going on because it was payment over a period of time. So he makes his payments under the assurance of discontinuance. We get the check, and we cut checks to the church for the 5 churches for restitution every quarter. And then with respect to the other pastor, we actually had to bring a litigation because we couldn't reach an agreement with him before, and we did sue him. It was ultimately settled. In the settlement, that pastor admitted having received basically about $450,000 from the same developer, including one payment to his wife at the closing of the sale of his own church. That is done in addition in that transaction. So this is a good example. The church, the board of the church, had actually agreed to pay him back salary, okay? $450,000 paid to him out of the proceeds of the sale of his church the day after the transaction closed. Never disclosed to our office, never disclosed to the court that was going to be done. So good example of, even in that case, the board supposedly authorized that, right? Like they said, okay, we're going to pay you $450,000 because we haven't paid you. They didn't disclose it to our office, and they didn't disclose it to the court to have us, review that and say, like, this is a good real use of proceeds. And so that was one of the causes of action in that case. So, and with the 2 clergy that we reached settlements with, they're actually permanently barred from, they cannot serve as fiduciaries in New York, not-for-profits, with an exception for ministerial or pastoral work. So we don't get involved, obviously, in that component. But in terms of overseeing finances and things of other not-for-profits, they're barred.
30 seconds on the last 4 years of my life. I've been almost primarily, if not exclusively, litigating with the National Rifle Association for the past 4 years. Not 1, not 2, but 3 trials in that time. But we just concluded a jury trial at the beginning of this year in favor of our office against both the NRA itself as an entity, but also against the 3 top officers who were still in the case at that point. But that resulted in about $5 to $6 million judgment against the former CEO and CFO. And also, we're currently in the process of figuring out what the ongoing changes to the NRA's governance structure are going to be. And, in fact, we have a court hearing tomorrow on that issue. But
one thing to just make clear, our office is mission neutral. I just want to make that. So it is not, again, as Stephen said very early on in our presentation, the money that's recovered, we're suing on behalf of the NRA. So even though it appears that we're suing, the money that's recovered would ultimately to go back to the organization. Yeah,
so the $5 to $6 million, all of that will go back to the NRA. It'll be a bit of a complicated process, but that's how it works. And, there are lessons to be learned from the NRA case, but it was so egregious in so many ways that I just don't think, I hope that they are not lessons that need to be learned. But for example, please do not let your CEO receive luxury yacht vacations on a yearly basis from a vendor who was doing about I think it was at one point about $40 million in business a year with the organization. And surprise, surprise, after the conflict came to light in our complaint, they were able to cut that amount down by like, was it 70%, something like that? And the CFO was helping him do it the entire time, and the board was asleep at the switch. The board, this was a pretty good example of a type of founder syndrome. The NRA is a very old organization, dating back to the 1800s. But the CEO, Mr. LaPierre, had been the CEO for about 30 years. And at that point, it was the board working for him and not the other way around. And that's not the way it's supposed to be. The board is the check and balance to the CEO. And the board was not asking questions. The board was deferring to him. The board was signing off on anything he ever did. The board wasn't reviewing his expense reports because expense reports were being reviewed by his secretary. It is a good example of how bad things can get if you don't catch it early enough. And it is a good story of how important prevention is, and like doing the work at the outset rather than having it go on for too long.
I think we're getting the going to get pulled off by the.
Thank you both. We're going to just have a few minutes so that you could go to the appropriate room for the next session, and that gives you a few minutes if you have questions for Stephen and Sharon. You can ask them now up here.